Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. With $1 million, we can make $5 million a year, easy and safely. Now that's a representation that was among some other representations that led about 5 plaintiffs to send a little over $2 million US off to the financial advisor who made these representations. Now, $2 million was sent off. Sadly, only about $1 million came back. So the representations about it being very low risk and these sorts of things did not quite play out as everyone might have hoped. So what do our 5-ish parties do? They decide to commence proceedings against our defendant. Now, our 5-ish plaintiffs, we've got one who's domiciled in Australia, who it looks like probably wouldn't have the money to meet a costs order if the defendant wins. We've got one in California, and we've got some in British Columbia, over in Canada. And what, as you probably know, or almost certainly know now, what a defendant who's being sued by some plaintiffs or a plaintiff who may not be able to pay for a costs order can do is seek security for costs, where in short, the proceedings get paused, and during that pause, the plaintiffs have to provide some security in case they lose and the defendant is entitled to a costs order. So what we're going to work through today is the defendant saying, hey, I want security for my costs from these 5 or so plaintiffs. So let's work through the procedural background, always the funnest kind of background to work through. Early in the matter, the defendant had made an application for security for costs and had already got $60,000 in costs. So that 60 is already safe. This application is for more, about 240 or so, because the hearing is coming up and the defendant says, right, we've got all these people who are outside of Australia, companies who may not have money, we need this security in place in order for the proceedings to go ahead. So the court works through what the defendant has to say. And the first question the court turns itself to is 60,000 enough for the defendant to be able to enforce a judgment over in California or over in Canada? And in short, the court works through some evidence from a Californian lawyer and some evidence from Canada as well. There's a decision relating to Jim Carrey, some enforcement of some decision in 1997 involving him that we can chat about over a coffee ourselves perhaps sometime. But in short, the court forms the view that the $60,000, the existing security already in place, would be enough for the defendant to jump overseas and go get his costs order enforced in California or his costs order enforced in Canada. But the court doesn't stop there. It works through some of the other issues raised. So one of the other issues raised is the prospects of success. Now, there are talks about fabricated screenshots and potential misrepresentations about numbers and the assertions the parties are going to make. And even though this is a preliminary hearing, it's a hearing before the final hearing, the court's seen enough to say, look, maybe it's not all that likely that the defendant is going to succeed in getting his costs order. And so for that reason, there's not a compelling impetus to grant security for costs. And then the court turns to timing. So the proceedings, if memory serves, were commenced in early 2018. A mediation fails in about November 2018. And from about that date, the court says, well, mediation, or the sort of structured settlement negotiation that very often happens in litigation, has failed. So from that time, we've got a failed negotiation. So from that time, we've got more or less certainty that the hearing is going to go ahead, meaning that at that time, the defendant knew he was going to have a fight in court on his hands, and so about that time, he should have made the application. Now, what actually happened is that he waited a significant number of months, meaning that the hearing was sort of coming up, and he really sat on his hands a little bit in relation to making the application, and the court found that that weighed against the necessity to make an order for security for costs. So in the wash up of all that, what the court found was that the additional security sought was not necessary, because the 60 grand that was already in hand would be enough to jump over to California or jump over to Canada or both to go and enforce a cost order, because due to the prospect of success for the defendant, which weren't compelling, the likelihood of a cost order was not especially strong, and also due to the defendant's delay in making the security for costs application, the court wasn't inclined to make it. So I hope that quick little jaunt assists you. I hope it provides you with a bit of value, and I hope you have a great day, and I will look forward to joining you for another coffee and another case note soon. Cheers.